Afternoon, we're going to call this full committee of Judiciary Non Civil to order. Before we get started, I'm going to ask that Representative Smith give us a word of prayer.
Yes. Lord Jesus, we come to you today thanking you, Lord, for the breath of life, thanking you most of all, though, Lord, for salvation, that we might have a restored relationship with you. Lord, we ask that you be with us as we go through this committee, Lord. Help us to seek your wisdom. Help us to have discernment in our decisions here today. We ask that you would bless our decisions. In your name we pray. Amen.
Thank you. We've got three measures to consider here today. I'm going to ask that we're going to go a little bit out of order, but I'm going to have Representative Rich come up and present her bill first. That's House Bill 94. And give me the LC number you've got, Representative Rich. Excuse me, hold on a minute. There you go.
I have LC 289958.
Thank you very much. Tell us what your bill does and why we need it.
Okay, thank you, Mr. Chairman. This is House Bill 94. And just by way of background, this bill actually passed this committee last year. It was never brought to a vote on the floor because I was personally out and sick for the rest of that portion of the session. So we have brought it back this year. House Bill 94 creates a new crime in response to the way society has changed and new crimes that criminals are committing. This creates the crime of possession of stolen mail. This means that an individual who is caught with at least 10 separate pieces of stolen mail that were addressed to 3 different addresses could be found guilty of the crime of possession of stolen mail. And this does create a felony. I also neglected to mention that this bill was requested by our U.S. Postal Inspector. I have Mr. Keith Spears, who is an agent with that office, here to answer any specific questions that anyone may have about the reasons for this bill. He has a lot of detail on the crime rings that have developed in response to the profitability of this new crime. That's the first portion of the bill. The second portion of the bill creates a felony for porch piracy. And as I was just explaining to one of my colleagues, that's kind of a cutesy name for a very serious offense. This would create a felony also for an individual who approaches the doorstep or the threshold of a home in order to steal a package without regard to the value of that package. And the rationale behind that is because it takes a much more brazen individual to commit that kind of crime. For the same reason that a burglary is a felony, this also should be a felony. This has started to happen with more and more frequency. In the past, this was not an issue. This wasn't really a crime that was available because in our society, we didn't have packages delivered to our front doors the way that we do now. And I want to mention too that this applies only if an individual does approach the threshold of someone's home to steal a package. The same state laws will continue to apply with respect to the value of a package if that package is actually stolen from someone's mailbox. Sometimes Amazon does deliver packages to the mailboxes, and that will continue to just be a misdemeanor unless it's worth more than $1,500. In closing, these crimes are committed disproportionately against our lower income citizens and our more elderly citizens. Checks are being stolen, medications, items that don't have a very large monetary value on their face, but can mean life or death or having the rent money for these individuals. So with that, Mr. Chairman, I would request the favorable consideration of the full committee.
Thank you, Representative Rich, or Chairman Rich, excuse me. I recall in subcommittee, and I think you restated it here, this is not just, an act where someone goes up and steals off of one person's, out of one person's mailbox. one of the things you highlighted was the fact that these kiosk type mailboxes, they were breaking these things and taking everything out of them. Can you go over that a little further or delve into that?
Yes, the postal inspector has provided me with some photographs of these kiosks, these mail boxes that are in group boxes that are routinely at apartment homes and in neighborhoods where we have more zero lot lines and we don't have mailboxes at the street, so that the thieves can come up and actually break into the big box and steal from multiple people at the same time. And just when I was developing the facts for this bill, the day before, the postal inspector provided me with these some statistics and information. There had been a search warrant that had been executed by the DEA with respect to a drug ring that they had been following. And it turns out that when they got into the motel rooms, they did not find drugs. They instead found mail from multiple mailboxes, pieces of mail, checks all over the motel room floor. This motel room was located in DeKalb County. The mail had been stolen from counties other than DeKalb. And this crime is actually going to go unprosecuted because the individual locales they cannot devote the resources to prosecute these misdemeanors. So this was a perfect example of how these lower income communities had been targeted, and basically these crimes are going to go unpunished.
Thank you. Do we have any questions from the committee? Did you want the gentleman to speak at all?
If there are any questions from members of the committee that I can't answer, then yes, he is happy to provide some specific information.
I'm just going to ask as a reminder, the House rules are requiring that if you're in the audience that you wear a mask. We've got to wear a mask. I don't necessarily enjoy it either, but please do if you are in the audience. I've got a couple flashing lights, so there are going to be some questions. Would you like to have him come up to the podium, or you're going to answer them? And if you can't answer them,
if the question is something I can answer, then I can. Otherwise, Mr. Spears can come up and introduce himself.
Okay, Chairman Reeves.
And I was just going to give a subcommittee report, so I can hold
Please
off
do.
until we're done.
You got a question on Zoom?
No, just we're asking to change it.
Who's number 14? Representative Lopez.
Thank you, Chairman. Thank you, Representative Rich, for bringing this up to us. I still have the same concern with this in subcommittee. I think the last time that I raised this, we talked a little bit about it within the context of Section 1, but it is within the context of Section 2, the Porch Piracy. Porch Piracy, I think that's how you worded that one. But so that creates a felony, and I agree with you that it takes a level, it is intrusive to come to someone's porch. But the same example of a 15, 16-year-old that has been ignorant and coming to my porch to take a package, he would be, or she, hit with a felony. So that's still my concern with your bill.
And remember that this is always within the discretion of the local authorities to charge. And I would find it hard to believe that with their stretched resources that they would want to prosecute a felony against a teenager who was stealing something of nominal value off of someone's porch. This is intended, though, to just bring our criminal code up to the level that it needs to be, or to meet society where it is and the way that we're living now, because so many people are having packages delivered to their homes that this has become increasingly prevalent and problematic. And it's just meant to provide some safety and security for people in their own homes.
Sure, and as this measure, if to Representative Lopez's point, if a 16-year-old goes up to just your porch, then under this new law, it wouldn't be prosecuted as a felony, because it requires 10 pieces of mail and 3 different
There are
names. Is that correct?
No, there are actually two different pieces
Mhm.
to this legislation that the postal inspector has requested. The first one is the mail theft ring, which does require the multiple pieces. And then the second portion is the Porch piracy
Mhm.
portion. So that actually can be prosecuted as a felony if it's just one package. And that would be up to, of course, the discretion of the local district attorney as to whether that office believed that this was a crime that fit the brazen nature that we're trying to address with this legislation.
Thank you. And just a quick search, looking at the U.S. code, the U.S. code says that any mail, just one piece of mail is a felony. So I appreciate
Yes.
that.
Yes, and that was something that the postal inspector has requested. They don't have this has become so prevalent that they do not have the resources to prosecute every single one of these, and they need the state's help with this problem.
Thank you, Representative. Representative McLaurin?
Thanks, Mr. Chair. And Chairman, thanks for explaining the bill. I think I may have just gotten my question answered by the back and forth you just had with the chair regarding the parallel to a federal felony for any one piece, irrespective of value. But the question I was going to ask you was essentially if you would be open to a dollar value threshold for the second crime, given that a bag, a small order, $20, $30 from Amazon might not rise to the level of seriousness that we would think in terms of a felony liability. But I think I know the answer.
Yeah, well, it would defeat the entire purpose of this legislation because we already have a misdemeanor for that. And this is actually meant to provide security in the home by creating a felony. Just for example, if someone were to break into your home and step across the threshold, that's a felony too, even if they steal nothing or if they steal something worth 50 cents. It's for that same reason that we believe that this is necessary.
And I actually appreciate that clarity because I feel like sometimes when we take no votes in committee, there's ambiguity about why, and people feel like there's some sort of lack of clarity. But at least I think with Representative Lopez's objection in mind, I think we have a good understanding of where the policy disagreement is. So thank you.
Okay, yes.
Yeah.
Mhm.
Thank you, Representative McLaurin. Do I have any more questions or discussion from the committee? I'm going to ask Chairman Reeves to give us a report of subcommittee.
Thank you, Mr. Chairman, and thank you, Chairman Rich, for bringing this measure for the second year. I've said this many times, and I'll say this in this venue as well. Our job as legislators and lawmakers is we have to evolve with the nature of crime. And in the last several years, the rise of e-commerce and the rise of the usage of home delivery has become a much more significant thing than it used to be. And, particularly, obviously, when you filed this bill a year ago, you had no idea what was coming in the next year and the increase in e-commerce that was about to take place, which is, I think, probably everybody in this room is engaged in some form or fashion. And the key to this issue, when we discussed this in subcommittee, and frankly, it's something that I feel very strong about. I believe very strongly in the castle doctrine. Your home is your castle. And a burglary, obviously requires you have to break through the threshold. You have to open the door and go inside. And whether or not you steal anything doesn't matter. It still can be considered a burglary. And the intent to commit theft can be simply implied, as our burglary law goes right now. That is a felony of 1 to 20. And while this act of stealing from your porch, it doesn't require actually entering the house, but it's just as, in my mind, it's just barely a degree removed in egregiousness. And as I said, I have a 12-year-old, and there are times where the 12-year-old is at home for an hour by himself when he gets home from school, or whatever it may be. And when someone steals something, comes to your front porch and commits a theft and steals something, it is a deterioration of the confidence that you have in the sanctity of your home. And if somebody came on my property and committed a theft like that, it would change the way that I probably feel about my 12-year-old being at home. I think that these things are to be taken very seriously. And the way that we do that is we have to develop a strong public policy that says when you mess with somebody's house or the property that is on their front porch, you have crossed a line, and you've crossed a line that is serious. And I think that this appropriately addresses that. And I thank you for the legislation. And we did debate this thoroughly in committee, and it was obviously debated last year. And I hope that everybody on this committee now will support this measure. Thank you, Mr. Chairman.
Thank you, Chairman Reeves. You don't have a button? What number are you? Representative Bodie.
Thank you so much, Mr. Chair. Thank you, Madam Chair, for bringing this bill. Again, I just want to kind of stress what some may or may not have said. I said it in the subcommittee. Again, in a scenario, and I hate to talk about scenarios, if we have a 17-year-old boy, girl, high school senior that steals an Amazon package that's full of vitamins worth $30, they will be looking at a felony of 1 to 5 years in prison. Is that not true?
Okay, yes. Let me let Agent Spears address that.
Good morning or afternoon. I'm not sure if we've hit noon just yet, but I appreciate the committee having me out here. My name is Keith Spears. I'm a federal agent with the Postal Inspection Service. So I did want to just make myself available to answer any questions. I was just talking to Representative Rich, sir. The juvenile piece, and I think if anything, we can divest the Porch piracy from the other mail theft. But the Porch piracy question that has been brought by both of the representatives over there, that would arguably be handled by the juvenile justice system. So while there is all sorts of felony statutes in the state code, those would be, most appropriately addressed in the juvenile justice system, regardless of the existence of a federal or of a felony statute. Much in the way that on the federal side, where I prosecute crimes, or bring cases for prosecution, there are we don't charge minors at all. So in my experience, I would say I have, in 7 years, I've probably been called once on a juvenile. Thankfully, we've got good kids in this state.
But respectfully, the age of majority, Mr. Special Agent, for state court cases is 17. And so a 17-year-old is treated as an adult in the criminal justice system on the state level.
Sure, I understood, and I apologize for that. I meant just juveniles in general, but yes, as a 17, you are correct.
And if I may respond to that, again, this is within the discretion. It means that the person could be charged with a felony. I am not aware of any district attorneys around our state who are using their resources to charge children with felonies for stealing vitamins. I do think, however, and in fact, I know as a fact because I spoke with the prosecuting attorneys council, they want this legislation because they want to be able to prosecute the dangerous people who are coming up onto our citizens' porches.
Thank you, Chairman. Chairman Reeves.
Thank you. And to respond to my friend Representative Bodie, I think that what I understand what you're saying and talking specifically about a 16-year-old, then you and I both know the mission of juvenile court, and that juvenile court is very focused on rehabilitation. And I think that, when juvenile court offers a plethora of programs, when, young people come through through the court for charges like theft, that may be serious charges, the court is very adamant about working with that young person to focus on rehabilitation. I think the second piece, you talked about a 17-year-old, and I think this is a great relevant conversation. And I think that what you're doing is you're isolating out all of the possibilities that exist in our current courts. We've spent years, almost a decade now, enhancing and creating diversion programs, accountability courts, alternative prosecution programs. I mean, I think that's to the point where if you're lucky, you get 3 bites at the apple before you get a conviction in some cases. And what you're saying, I think, is not accounting for the fact that there are so many alternative prosecution programs that are available that are especially used for young people that are going through the court system for their first time. And I would also tell you that it's not that far removed from other policy. Entering auto is a felony. And that would be, you know, for a 17-year-old, entering auto would be the, you know, opening somebody's, you don't necessarily have to break it, opening the door to somebody's car and getting in with intent to commit a theft. That's a felony. And I you know, I don't want anybody entering in my car, but I'll be honest with you, I'd much rather, I'd feel safer on the scale. I'd rather be upset that somebody entered my car than somebody came to my porch and stole something, just personally. But so, you know, I think that there is plenty of wiggle room here for the courts to be able to do one. And as you know, and I know, any offense, any felony offense that is eligible for sentencing of less than 10 years, the judge has a discretion to sentence as a misdemeanor, and this would be not an exception to that as well. So I think that that while we have focused heavily on really kind of packing our criminal justice system with a lot of these great programs that help people make better decisions and realize not to make mistakes like this, but I think on the other side of that, we have accountability. And this is one of those matters that I think is serious. And my God, this problem is not getting better. Like, this is getting worse. And as people continue to engage in e-commerce on Amazon and whatnot, it's only going to continue to grow as a problem. And I think we have a duty to address that. And I think that this is a proper way for us to do that. Thank you, Mr. Chairman.
Thank you, Chairman Reeves.
Of the speaker. Thank you so much, Madam Chair. And my dear friend, Vice Chair brought up a great point, and I want to know if you would be amenable to a potentially friendly amendment of adding exactly what the chair was stating, that in the discretion of the trial judge as for a misdemeanor, that basically that if the trial judge wanted to, pursuant to OCGA 1689, that they could actually sentence this as a misdemeanor and put it in code so it would not be, you know, left up or ambiguous at all. Because it's in current code right now in the theft by taking punishment statute.
No, we are not, because again, I am not willing to gut this bill. This bill has been requested by law enforcement, by U.S. law enforcement. It has been backed by the Prosecuting Attorneys Council. Those are all of the prosecutors in our state. The judges like this bill. I am not willing to gut it. This bill protects Georgians, and that's the way it's going to stand.
Thank you, Chairman Rich. I appreciate you bringing this piece of legislation. I think it's an important issue, and I think we've had a healthy dialogue here, and I appreciate everybody on the committee. Now will be the appropriate time for a motion. We have a move to pass. We have a second.
Second.
Do we have any amendments? We have no amendments. Hearing none, I'm going to call the question for House Bill. Where we at? House Bill 94, LC number 289958. All those in favor signify by saying aye.
Yes.
All those that are not in favor signify by saying aye.
No.
Oh, excuse me.
That was tricky.
Okay, so all those in favor, one more time, raise your right hand. All right,
I'm raising my hand here.
4. We got 4, and then online we've got an aye.
Aye.
Any opposed? Is the opinion of the chair, the measure passes on the rules. I appreciate it, Chairman Rich, and
Thank you.
you come by the office and get a rule sheet, and we'll get you squared away.
Thank you very much.
I appreciate you. I was giving you guys a second bite, you know. Okay, thank you very much. Let's move on to what we got here now. Representative Gunner, We got House Bill 371, and we have a substitute for that, I believe, correct?
That is correct, Chairman.
Thank you, Representative Gunner. Go ahead and tell us what your bill does and also why we need this bill.
House Bill 371, we call it the video conferencing bill. Basically, it adopts the rules of the courts in conducting virtual hearings. This is a safety measure. It's a cost-saving measure. It's supported by Council of Superior Court judges. The Department of Corrections is also in on this. And we've had the input from the Supreme Court as to the wording in it. And so I think it's a valuable bill for the state.
I'm just going to read for clarity to make sure we all have the same substitute here. We've got LC 280266S. Is that the one you're working off of?
You have what?
I took all of yours, didn't I?
You got everything.
Okay.
If you have an extra, I'll take it, yes.
Understanding any provisions.
So I have LC 280266S.
All right, thank you there. Is there any discussion from the committee? Representative Gunner, I have a quick question.
Yes, sir.
Is this one of the bills that came out of the Judicial Council?
I don't know that it went through the Judicial Council.
No, it did
I don't
not?
think
Okay,
so.
all right. Judge, if you would come up to the podium.
Mr. Chairman, thank you very much for recognizing me. I'm Judge Tane Kell from the Cobb Superior Court. We consulted with both the Supreme Court and with judges at all levels of court. As you can see from the bill, that judges not just in the Superior Court level, but judges at all levels of court would be included in the language of this bill, incorporating their uniform Superior Court rules or their uniform court rules for their level of court. So while it is not a Judicial Council bill, all levels of court have been consulted with respect to this bill. Yes, sir.
But and the impetus is to improve the efficiency of the courts. Is that correct?
Absolutely, and safety as well.
And the safety.
Yes,
Okay. Do we have any questions from the committee? Any discussion? Well, at this point, then, if there's no questions or discussion, then it'd be appropriate time for a motion. What number are you? 15. Go ahead.
Mr. Chair, make a motion to do pass.
We have a motion and we have a second. Is there any discussion? Any amendments? Without any, I'm going to call the question for House Bill 371, LC 280266S. All those in favor signify by saying aye. Aye. Any opposed? The measure passes on the rules. Appreciate you,
Mr.
Judge
Chairman,
Gunner.
and members of the committee. Thank you.
Thank you all.
All right. Now, we've saved the best for last here. I think there might be a discussion on this one. Is this the correct one?
That should be the most recent one.
Okay. House Bill, the next measure we have is House Bill 194, our Representative Sains. And if you can present from right there if you like. Tell us what your bill does and why we need it.
All right, Mr. Morgan. Thank you, Mr. Chair. And I know we got a late minute substitute. However, it is reflective of only the items mentioned in committee yesterday. There is nothing else taken out for those interested stakeholders, or put in or taken out for those interested stakeholders. LC 480396S. And if it's okay with the chair, I'll highlight what has been changed from yesterday's conversation first, which is it starts in line 207, dealing with exploitation of children. It adds what GBI testified on and the Prosecuting Attorneys Council agreed upon in terms of modifying how the charges in relation to pictures are conducted. I think there was conversation about a tier system. The PAC will at the appropriate time testify to why they felt that would not be something that could be done. Again, this is I see the just reason for it. I'm neutral on it being included, and I think there will be discussion on that. And then on line 458 just adds pardons and parole into the notice. We added the District Attorney's Council, and we wanted to be parallel with their important work and their significant role for advocating on the victim. So we added them as well. With that, just as a reminder, this is a response to the Supreme Court decision, Walker v. State, that made it to where Georgia sheriffs could no longer, as based on a condition of their monitoring of the sex offenders in the county, for those that they felt necessary in being of a significant increased danger to the general public, to have the use of a very proven deterrent, which is GPS monitoring. This where that Supreme Court decision made it to where hundreds of sex offenders, and the majority being dangerous sexual predators as leveled by the state, went from being monitored to not being monitored. This is a very specifically crafted legislation to where, if we look at Department of Community Supervision data, if this does not go back, it goes from when it's passed forward. But if we were to look just to get a picture of how limited this policy is, if we look at everyone in DCS custody right now, it would apply to less than 50 individuals. So going forward, it is going to be a very specifically targeted piece of legislation. It requires the individual to have been twice adjudicated into the 13 listed crimes. It will, and to note, there's been a lot of conversation on judicial discretion. I'd point everyone to section 5.5 when it comes to that. We give judicial discretion. We put consistency in the front end, knowing that the most significant data that the state can gain in terms of a sex offender's significance on reoffending is gained through their custody with the state. This does give judicial discretion at that 10-year mark that the state is responsible for when it comes to that end. So with that, I think we're ready for a motion. Just kidding. Just kidding. He wasn't.
Thank you, Representative Saines. Does anybody have any questions for the author of the bill? I know I have some folks online that want to speak to this, but I'm going to ask the committee first to question the author. Thank you.
Thank you.
Representative Kendrick.
I have a question about lines 61 and 62, actually that whole paragraph 60 through 65. And we're doing LC 480396S, right? Okay. So the paragraph, the two questions that I have is it involves a victim who is less than 14 years of age. Is there a particular reason? Is there somewhere else in the code where 14 is the years of age as opposed to like 16 or some other age?
I believe that is relevant. I know that the question had been asked, and we approached it with legislative counsel. If they're on, they can please contradict me if I'm incorrect, but I believe it's parallel to the current code. That's why they based it. There was no policy request on there.
Okay, and my second question is the exception between the comma of except by a parent. So is this paragraph to read that if a parent was previously convicted of a sexual felony that involved a victim then less than 14, then they would not be punished by life in prison or the split sentence?
Representative Kendrick, which line are you on now?
62, the part that says except by a parent.
Okay, thank you. Go ahead. Go ahead, proceed, sorry.
At the inclusion of a question about a comma, I'm going to ask legislative counsel to interdict. I don't want it. So you're asking if that comma, that back and forth, Could you repeat your question? I
Yeah,
apologize.
sure. So line 62 that says except by a parent. So I'm assuming the except language in the context of the whole paragraph means that if a parent commits a previously convicted sexual felony of a victim less than 14, then they would not be punished by imprisonment for life or a split sentence. Just the way that it is inserted is except by a parent. I'm just trying to understand the paragraph.
That would be my understanding, but I would let Chair Reeves speak to it.
Chairman Reeves?
My understanding of this issue is obviously you have a lot of times where there's a custody dispute between parents. And sometimes one parent has full custody and the other parent has visitation. And therefore, if a parent that has just visitation and not custody decided to, exercise some time that they may not be legally allowed to take, what this does is while that situation can be dealt with in other aspects of law, including contempt, et cetera, it carves that out so that's not looked at as a kidnapping. And I think that that's proper, even though if a parent abuses their visitation rights, that's a serious thing, but there are ways in law that we deal with that right now. And I think that it's not proper. I don't think it's good public policy to consider that a kidnapping. Does that make sense?
Yeah, so then the follow-up question, if I may, is that sexual felony or kidnapping is under the category of sexual felony is what you're saying?
I mean, tell me I need the context of.
Because I thought we were only talking about sexual felony. So I'm trying to see why is there an exception? I understand what you're saying.
I think that what this means is that if a person has and Representative Sainz, please correct me if I'm wrong, but if a person has a prior conviction for a sexual felony, and then they commit a second offense, which would be one of the offenses enumerated here. And in this case, it would be that they've previously kidnapped somebody under 14, and then they kidnapped somebody under 14 again, or committed another sexual offense, then they would be eligible for this enhanced punishment.
And I'd concur with that. And I think what you're alluding to, it's not captured as a sex offense. And I do apologize that this was correlated to the conversation on this bill in committee last year. And the justification for the inclusion of this offense would be that it is child endangerment and very typically associated with dangerous sexual predators when taken into account another crime.
Representative Kendrick, is that you satisfied?
I'm still a little confused, but I'll go speak to him.
Thank you. Any other questions from the committee before I go to the folks online that have signed up to speak? Is anybody in here going to speak in person? So I'll let you do that first. Okay. All right. So then let's move on to Jill Travis. Can you unmute yourself, Jill?
I can, and I will. Good afternoon, Mr. Chairman and members of the committee. Thank you for letting us appear remotely. I am the executive director of the Georgia Association of Criminal Defense Lawyers. I'm looking at your face, Mr. Chairman. Are you hearing me okay right now?
We can hear you.
Okay, great. I think your patience is probably limited with my commentary on this bill, so I'll try to be brief and talk about matters that are new for the discussion today. In particular, on page 10 of the bill at lines 218 to 221. And let me also express my gratitude to Representative Sainz for sharing the draft of the sub. I know it just came out, and do appreciate being able to comment with using line numbers for you all. This language that was added with regard to prosecuting child, I'm just going to call it child pornography cases, because I think that's really the issue that's mostly involved in these kinds of prosecutions. The language that's added is doesn't take into account how images are downloaded and how they are downloaded in files, not by specific images. When you hit on one image, you would get a file. And so we don't think that takes into account the evil that you're trying to cure. I mean, the truth is there's a lot of forensics that can be used to prosecute these cases with multiple images and multiple viewings. And so we think that this change is unnecessary, and it's also not related to the underlying bill. And so we'd ask that you take lines 218 to 221 back out of the bill.
Ms. Travis,
Yes, sir.
would you unpackage that a little bit? I'm not quite understanding what you mean by if you click on one image on a computer, then there's going to be multiple images. Is that what you're implying?
Yeah, when you and I have to say I don't know a lot about how it works at all, but I do understand from folks that have defended these cases that generally speaking, when the computers are seized, that's the images that come into play, and it depends on how the prosecution charges the case. For example, if let's just say somebody looks at one image on one day, but has downloaded a bunch of images all at the same time, you're saying that you can prosecute for the images that weren't even viewed because it's the depiction of one. Each depiction of a visual image constitutes a separate offense. That seems confusing to me. And doesn't take into account how this is actually done. And I think the other issue with this is again, the viewing versus the doing. This crime, one image, let's just say we just have one image. One image carries 20 years. That's a lot of time. So 2 images carries 20 years, and so on and so forth. You can do the math. It's not as if there isn't plenty of punishment that's available for these types of crimes. So we'd ask that change not be made, or if it is made, it's not made in this particular bill. And then with respect to the other crimes that are involved, and I'm not going to repeat myself, but we have asked that the committee consider changing life sentence punishment to being punished as a permissible life sentence, not a mandatory life sentence, and the same with lifetime monitoring. We have not spoken with regard to all of the things that come along with lifetime monitoring and the costs and the expenses that are involved in that. And I won't go into those details, but several of these crimes already carry life sentences on a second offense, but several of them don't. And specifically, statutory rape, enticing a child, computer pornography. We most especially think those should be changed to may in the particular instances. I can come back and put it in the chat if that shows the line numbers where the mays, we would ask that the mays be to shalls. In my dreams, I would like to have all of the shalls be changed to may.
Which ones are you asking for, may to shall?
Can you give me just a second to look? Can I give my first tier and my second tier? My first wish list would be lines 115, 116, 136, and 138, and 214 and 216. And then when I woke up and really thought you guys were caring about what I was having to be concerned about here, I would say, and I wish you, I don't know if you can see the smile on my face when I'm saying that. So I'm being a little bit of a smart aleck, and with no disrespect, Mr. Chairman. 45, 47, 62, 64, 84, 86, 94, 96, 104, 106, 115, 116, 126, 128, 136, 138, 149, 150, 159, 161, 169, 171, and then the ones in the 200s that I said earlier, which is 214 and 216.
Thank you.
That's all I have, Mr. Chairman.
Is that all you have? I appreciate your input, Jill. You've been very helpful with this bill, particularly with the structure of the bill. And I understand that while we may have a difference in policy, you're always looking towards making sure that good law is put out. So I appreciate you. We've got, do you have any questions for Jill, committee?
I did just want to echo the chairman's comment. I had not given any credit to Ms. Travis just because I didn't want to make her associated to a bill she didn't support. But for someone who has an issue with some of the policy here, she has worked extensively to help this committee structure it in a way that is most appropriate.
Thank you. All right, we've got one more signed up. Going to ask that Brenda Spar, please unmute yourself. Brendan Spar. We can't hear you at this point, Brendan. Let me see if I can get the media folks to try and help you out. Have you got any?
Can you hear me now?
We can hear you now.
Okay, great. We'll just go without earbuds. And I'm embarrassed to say I am the executive director of Restore Georgia, an advocacy group for people on the registry and their families. But what I'm embarrassed to say is the second part, that I'm an IT consultant in my spare time, and technology is always a challenge. But I'd like to speak about the internet pornography piece real quick, because that is kind of my background with technology. Where you run into the problem is the temporary internet files. When you visit a website, it likes to load everything for speed in the background. So if you're visiting a pornographic website, the opportunity for preloading a lot of pictures and images without your knowledge is there. So you could be at a pornography site that maybe has some illegal pornography on it, and you will only view one image, but hundreds and hundreds could be preloaded in your computer without your knowledge. So I would ask that the committee change it to knowingly possess instead of possesses. So knowingly, this is where you're hoarding it. You have a folder of pictures that you look at regularly, and not temporary internet files. So that's on the temporary internet file issue. We do have an issue with, again, like Ms. Travis mentioned about this shall and may. We don't like judges' discretion being taken away from the judges. So anytime that we can put the full picture and not just the charge that has been levied against someone, each case is individual, and having the judge give discretion in each case is probably the best idea, we feel, at Restore Georgia. And then the third item that we kind of have an issue with is Section 1D on the Halloween signs. This would require law enforcement to place a sign at the residence of someone on October 30th and 31st. That has actually been challenged in the Middle District Court of Georgia successfully. There's been injunctions that have been granted against Butts County, and Spalding County has settled out of court on these signs. They were found to be unconstitutional for compelled speech on the First Amendment. So we would ask that that line, that Section 1D be removed, the Halloween signs. It detrimentally impacts the family members. Anyone living in that residence has a sign placed in their yard that says, don't trick or treat here, no candy. So in one case, one of our constituents had a 6-year-old daughter, and his adult parents were living at the house. They all were subject to that sign and the impact of that one person on the registry living in that house. So we'd ask that 1D be removed.
Brendan, thank you for your testimony. Do you Does anybody in the committee have any questions for Mr. Spar? No questions.
Thank you.
All right. Thank you, Mr. Spar. Okay. Representative Saines, do you have any closing remarks regarding your bill?
Yeah, I'd like to speak to the last presenter. It was reflective on the current bill that we found it to be more pertinent to make sure the significant policy implications of the bill, which were the SOAR modifications to expedite and make the efficiency changes to the leveling of these offenders, because it has significant contributions to the safety of the public at large, as well as the creation of a mechanism to balance the hundreds of offenders who now go unsupervised with this with GPS monitoring. I do not believe we kept the Halloween provision, so just noting that, unless I am wrong. And I feel comfortable with Representative McLaurin shaking his head at me. I think this is an affirmative stance.
Well, thank you. At this point, if there are no more discussion on the bill, I know that Representative Saines has been very willing and able to work with many of the parties that are involved here, and this bill has been batted about subcommittee multiple times. Representative Reeves, did you want to give a subcommittee report? Or excuse me, Chairman Reeves.
I think we've gone around the circle on this a lot here today, and I think that everybody knows what we're looking at this point. But obviously, this bill we've been contemplating this for over a year now, and we've had a lot of collaboration and have landed at a place where I think it makes some substantial improvements and allows judges the ability to make certain decisions on predators that need to be monitored for the rest of their life. So that's all I have to say, Mr. Chairman.
Thank you, Chairman Reeves. I got one flashing light. It's Representative McLaurin.
Thanks, Mr. Chair. I wasn't sure if you wanted to do overall discussion now or on a motion, but since you had mentioned no more discussion, I just thought I'd light up in case now was the time. At the pleasure of the chair. I don't know.
Well, let's get into the posture of a motion.
Okay. Yeah,
if you'd
that's
like.
what I was thinking. Okay.
Representative Gravely, please unmute yourself. I see you got your hand up online.
Thank you, Mr. Chairman. An online question. I guess one of the presenters or one of the associations said that in regard to the previous speaker, Brendan, I believe, it's saying that the Halloween signs are no longer in the bill. And I didn't know if that needed to be stated for the record or if that,
Yeah, that's
was the case.
I think Saines said that for the record, but thank you for highlighting that. Just to be clear, that section is not in the bill, not in this LC.
Okay, thank you, Mr. Chairman.
Representative Smith.
Mr. Chairman, at the appropriate time, I'd like to make a motion.
Now is the appropriate time.
I moved to do pass.
Do I have a second?
Second.
We have a motion to pass and a second. Do we have any discussion by committee members? Representative McLaurin.
Thanks, Mr. Chair. And I assume there's still an amendment opportunity after this. Okay.
Yes.
The only thing I'll say, I mean, at the top, there's been a lot of good work done on this bill, and I think we've done a good job recently of distinguishing between disagreements on policy, like the discussion earlier today, versus getting things right for the purposes that they're supposed to serve. So I'm really thankful to the committee for all the work that it's done. And I don't want my vote to reflect that. I'm not grateful for that. I will say I did not get an opportunity to work with PAC on lines 218 through 221. And I have to believe there's a better way to handle multiple offenses than to make every image chargeable. I understand that multiple copies if they're identical copies, potentially you're not going to give rise to multiple offenses. But again, thinking about changing technology, some of the comments have been made today, it's too easy, frankly, to incur thousands of years of criminal liability. And at some point, I know we see headlines all the time with numbers that don't really translate to what a human being can serve. But at some point, we're basically just we're merging or collapsing these types of offenses into, unlimited criminal liability. And that's a policy judgment. That's not a policy judgment I agree with. So I wish that there were a better way to handle this that we had considered. And maybe there'd be an opportunity for this body to come back in the future and be more granular. I think the political will to do so at that time would be almost non-existent. So that's unfortunate, probably, to move the needle back. But I just want to say that for the record, because again, it's a policy judgment we're making today on that front, and I don't think it's the correct one. So thank you.
Thank you, Representative McLaurin. I understand your point, and in discussions, and the author can chime in here, and even Chairman Reeves, and that there is a significant difference if you have, from a policy standpoint, from one piece to 10,000 pieces, and in practice, I believe, according to PAC, it's likely not. The severity should be ratcheted up, but I don't think that they're going to, if there's 10,000 distinct images, I don't believe the intent is for them to charge 10,000 times, though that they will have the opportunity with this bill, and I understand that. I appreciate it. Does anybody have any more discussion? Any amendments? Chairman Reeves.
Thank you, Mr. Chair. I would like to propose an amendment on, it would be lines 115, 116, 136, 138, 214, and 216, and they're all the same. It's changing the word shall to may. This would apply to 3 categories, 3 of the 12 offenses that are in this bill: statutory rape, which is the first, enticing a child is second, and then exploitation is the third. These, the 12 offenses that are captured in this bill, frankly, some of them are just the most horrible things that you can imagine. And the 3 that I've named are also highly egregious, but there are varying degrees on that. And I believe that a judge can make the judgment in as far as whether or not these 3 offenses, whether or not somebody needs to be on probation or monitored for the rest of their life. And so my amendment is just to simply change the shall to a may and give that discretion. And I appreciate the author of the bill. Is preferring that we not make this change, and so I will leave it to the will of the committee. But I would change shall to may on those 6 lines.
Thank you.
Just make sure I got it right. It's 115, 116.
115 and 116.
138, 136, 138,
136, 138.
214, and 216.
214 and 216. So we've got a proposed amendment, and that's a shall to a may. Is there we'll call this the Reeves Amendment. Is there a motion on this amendment?
I move.
Is there a
I
second?
I second. Gravely online.
We have a motion and a second. Is there any discussion? Representative Sains.
And I think there's the Chairman Reeves putting this forward is reasonable in terms of what he's dictated. I want to make sure the committee highlights a few safeguards in this bill when considering that. I understand the distinction in severity of those charges. However, it's important to take this into the context of putting these 12 charges into consistency of having the same broad standard to where I or anyone else can go back to their constituents and say, we had 2 years ago hundreds of offenders able to be utilizing this prevention safeguard. We are now, and I believe, if I'm I believe I'm correct in saying that this is the only bill in relation to that modification being considered in both chambers. We are taking a very minimalistic approach and a very scoped approach because it is significant to add a lifelong concurrent sentence of probation. The other item to this is being, and note that though these offenses might be reduced, they must be in combination with another adjudicated offense within these 12 laws. That is one of the biggest modifications we've made to this bill, and it was reflective of last year's stance. It was reflective on the vote of the House at that point in last session. So I would be very hesitant to scope it in even more, where the work of this committee is going to be refined to where it's less applicable to any individual. And I do feel comfortable in saying that the bar we've set in this committee is a just bar, and it gives after 10 years. When we talk about judicial discretion, we're not against judicial discretion. We're just trying to follow the data and the science behind dangerous sexual predators, and knowing that the most dangerous of offenders are likely to have offended without ever being adjudicated. And we're asking in this bar to have the prosecutors proven twice. And let me restrain on that. After 10 years of serving, a judge does have the discretion and has the discretion of reviewing that case, the custody of this. They have the ability to get off of this life probation. So to say this is a generic life sentence that we're just throwing on there, which the chairman is not saying, I just want to make that point, would distract from the argument. So I just want to enter that in. I respect the amendment, and I know the chairman respects just my preference not to have it, but that's where.
Thank you, Representative Saines. Thank you, Chairman Reeves. So to the Reeves Amendment, let's take a vote. All those in favor of the Reeves Amendment signify by saying aye.
Aye.
Let me get a count. Raise your hands if you're in here. 1, 2, 3. And what do we have online? Who? And grab it.
No.
Did you say no?
Gravely said no.
Oh, my apologies. I have those that aren't in favor of the amendment signify by saying no.
No.
Is that
No.
4? So the amendment doesn't pass. I appreciate that, folks. Thanks you to the chairman and to the author for delving into that. Well, we're in the posture now that we have both a motion to pass and a second without amendments on House Bill 194 LC 480396S. And at this point, I'm going to call the question. For all of those in favor of the passage of this House Bill 194, please signify by saying aye.
Aye.
All those opposed? As the opinion of the chair that this measure passes on to rules. If you would, Representative Saines, can we get a rules sheet and we'll get this moved on. That's everything that we have on the agenda to take up today. I appreciate everybody's attendance, and I appreciate everybody that testified today. I believe we have subcommittee upon adjournment here in 5 minutes. So we're going to adjourn this full committee and we're going to move into subcommittee. Thank you.
Mr. Chairman,